What is motion for sanctions? A motion for sanctions is a formal request asking the court to penalize a party, attorney, or both for litigation misconduct, ranging from frivolous filings to discovery abuse or bad faith tactics. The purpose is not only to punish past behavior, but crucially to deter future violations and protect the integrity and efficiency of the judicial process. In U.S. practice, several legal bases authorize sanctions. Rule 11 of the Federal Rules of Civil Procedure polices papers filed with the court, requiring that factual contentions have evidentiary support, legal arguments be warranted by existing law or a good faith argument for change, and filings not be presented for improper purposes like harassment or delay. Rule 16F targets non-compliance with scheduling or pre-trial orders. Rule 37 governs discovery failures, non-responses, evasive answers, disobedience of court orders, and spoliation of electronically stored information, ESI, under Rule 37E. Beyond the rules, 28 U.S.C. Section 1927 allows sanctions against attorneys who unreasonably and vexatiously multiply proceedings, and courts retain inherent power to sanction bad faith conduct that undermines the judicial process. How does a Rule 11 motion work? It includes a safe harbor. The movant must serve, but not immediately file, the motion and give the opponent 21 days to withdraw or correct the offending paper. If the issue is cured, the motion should never reach the judge. If not, the moving party may file, and the court may impose non-monetary directives, monetary penalties paid to the court, or fee shifting to compensate the movant. The core inquiry is objective reasonableness at the time of filing. Discovery sanctions under Rule 37 are broader and often harsher. Available remedies include compelling responses, ordering costs and attorney's fees, precluding evidence, deeming facts established, striking pleadings, staying proceedings, or even entering default judgment or dismissal. For ESI, Rule 37E calibrates remedies to the level of culpability. If information that should have been preserved is lost and cannot be restored, courts may order curative measures for prejudice, but the nuclear options, adverse inference instructions, dismissal, or default, typically require a finding that the party acted with intent to deprive. Courts apply proportionality and due process. Judges consider the nature of the violation, negligent versus willful, the prejudice caused, the need for deterrence, and whether lesser sanctions would suffice. Severe sanctions like dismissal or default are reserved for extreme cases and usually follow graduated warnings or prior orders. When attorneys, not clients, are at fault, courts try to target the responsible actor to avoid unfairness. Practical mechanics matter. Many districts require a pre-motion meet and confer for discovery issues. A well-constructed motion will 1. Anchor the request in the correct rule or statute, 2. Detail the misconduct with dates, transcripts, and exhibits, 3. Demonstrate prejudice and cost, and 4. Propose a tailored remedy, e.g., limited preclusion plus fees. Overreaching can backfire. Courts disfavor sanctions motions used as tactical bludgeons. Conversely, if you're the target, promptly remediate, supplement discovery, correct filings, and present affidavits explaining what went wrong and how recurrence will be prevented. Typical scenarios. 1. Frivolous pleading. Counsel files a complaint recycling claims already dismissed with prejudice. After safe harbor notice, they refuse to amend or withdraw. The court grants Rule 11 sanctions, ordering fees and a penalty to the court. 2. Discovery stonewalling. A party ignores 2 orders compelling production. The judge precludes key evidence and shifts fees under Rule 37, warning that continued defiance will trigger default. 3. Spoliation. An employee wipes a phone after a preservation letter. Finding intent to deprive, the court issues an adverse inference instruction and imposes monetary sanctions. Strategic tips for exams and practice. Always tie the sanction to the articulated goals of deterrence and case management. Show why lesser measures won't work. And remember the procedural gateways: safe harbor for Rule 11, meet and confer for discovery. Preserve your record. Ask for findings on willfulness, prejudice, and proportionality, because appellate review often turns on those specifics. Above, I've left more videos so you can keep learning law. Remember to leave us a like and subscribe.